Hello everyone and welcome to another edition of On Our Terms, a video series by AIA Contract Documents. In this video we're going to be talking about the contractor's obligations regarding permits, fees, notice, and compliance with laws. My name is Mike. I'm joined by my colleague Jimmy Germano. We're both staff attorneys for the American Institute of Architects in Washington, D.C., and we work in the Contract Documents Department. As always, we can't give legal advice on this video, and please see our disclaimer on the last or second to last slide of this video for more information about that. Jimmy, take it away.
Thanks, Mike. So as Mike said, today we're talking about Section 3.7, which is entitled Permits, Fees, Notices, and Compliance with Laws. It's a relatively straightforward section. It's 3 subsections, but I'm just going to go through them sort of 1, 2, 3 and explain a little bit about what they mean, what they say, and some maybe reasons why they're worded certain ways. So first, let's talk about Section 3.7.1. States, of course, unless otherwise provided, the contractors shall secure and pay for the building permit as well as for other permits, fees, licenses, and inspections by government agencies necessary for proper execution and completion of the work that are customarily secured after execution of the contract and legally required at the time bids are received or negotiations concluded. That's a very long way of saying if there are permits, fees, licenses, or inspections that have to be done and paid for, the contractor has to do them and pay for them. The reason why, sort of the nuance of this section is in that second to last line, it says customarily secured after execution of the contract. It's worded that way because before execution of the contract, those similar types of fees or items are typically the owner's responsibility. So moving on to Section 3.7.2. This section, I'm not going to read it, but this is basically if the local jurisdiction has requirements for notice, if there's like a planning board meeting that has to occur, or architectural review board, something like that, then it's the contractor's obligation to provide those notices to make sure that they comply with those local ordinances. And then lastly, 3.7.3 essentially puts a burden on the contractor to not perform work contrary to applicable law knowingly. And Section 3.7.3 has a knowing requirement of the contractor. Basically, the contractor can't do something knowingly. If it does something negligently, that's potentially a different issue. If it knew or should have known that this was a violation of law, but it's a knowing standard because the contractor typically, certainly in a design bid build scenario, doesn't participate in the creation of the contract documents. So if it's performing work, then it's simply following the contract documents, not knowing that that work is contrary to applicable law, building code, for example, then 3.7.3 might provide some protection. But if the contractor becomes aware that the work is contrary to law, then it shall assume appropriate responsibility for such work and bear the costs attributable to correction. And I think that's it. Mike, did I miss anything?
No, just a little bit of clarification on the building permit issue. I think sometimes owners who are a little bit newer to the development process, the first entity that they're going to be talking with a lot is the architect, and maybe sometimes there's some confusion about the architect and their responsibility with regard to building permits. So it was really nice that you clarified this is a contractor responsibility to secure and pay for building permits, but often the architect and the engineers are going to have some involvement assisting the owner in issuing the documents or submitting the documents to the building department, maybe even going back and forth with regard to a comment and response period. But ultimately it is the contractor's job to pay for these building permits. So there's a little bit of an interplay there that owners should be aware of.
Sure, absolutely. I mean, yeah, I think it's the language of 3.7.1 talking about whether it's typically secured after execution or before execution of the contract can definitely blur the lines a little bit with respect to that interplay. So that's a really good distinction to highlight.
Sure thing.
And if you like this video, you can check out some more on our YouTube page and subscribe and click the bell icon if you want to get notified when we post more. And if you want to learn more about our contracts and the agreements and the information we provide, you can check us out at aiacontracts.org/learn. And if you have questions about the document content, you can contact us at the information in the middle of your screen. And if you have questions about the online service, like a technical support question, you you can contact us at the information on the bottom of our screen. And as Mike mentioned earlier, this of course is our disclaimer. And that's it. Thanks very much.